Well, I think that if there wasn't something that Governor Walker had to hide, that he wouldn't be trying to get a negotiated settlement. I think the statement that he put out totally obfuscated what's going on. It referred to federal information as opposed to state, where his case is currently at. And I think it just shows, again, that there's something there. Governor Walker is very concerned about that. And I note that, you know, all this discussion about a settlement comes after there's been discussion about the records being made public from the investigation, and I think that's what he fears the most. Because as we know from the last time Governor Walker had records from his office become public, there was homophobia, there was racism, there were incendiary remarks about people with mental problems. You saw that Governor Walker was utterly micromanaging the message delivery, and you also saw that his county office and its business was being dictated by what his campaign for governor thought was most strategic for them.
They've been pursuing a theory, and this is what I talk about pre-dawn raids, in pursuit of a theory that there's been illegal coordination. Well, illegal coordination, what is coordination? It's communication, it's speech. So that's why this is a federal lawsuit, because we've got a thing called the First Amendment here, and can people of like minds talk politics with other people of like minds? That's really what's at the basis of this. No, I don't think that Scott Walker has anything to fear about this, but obviously, you know, you're seizing upon Scott an offhand remark, a bad joke. I'll tell you what, you go through how many thousand emails they went through, if you can't find some little untoward statement that you can ride your high horse on, then you're more perfect than I am, to be quite honest about it.
I'll let you respond.
If you'd like to show us your emails with racist and homophobic jokes, I'm more than happy to see them, I guess. What I'd say to the statements, Greg, is this. Is that this notion that this is a First Amendment violation is probably one of the most ludicrous things that has come out of this in the central part of the Club for Growth case. Very clearly, there are laws that are in place that allow organizations like Club for Growth to not disclose their donors, to raise unlimited money, to have different limits than political action committees have. Okay?
Well, that's also a law.
And it's a tax, and it is a tax implication as well, because you don't have to pay taxes on the money that you have come in when you're a group, 501c4, for instance, like Club for Growth. They knew what the rules were. They knew what the law was. They weren't complaining before the election about the laws being a violation of their First Amendment. It was only after they got caught that suddenly they are making this case. And I think it's a pretty good indication, you know, that they're dead to rights on this when you have them saying, well, the law just, you know, it's not that we broke the law, it's just that the law is bunk. And that's as close to an admission of guilt as one could have.
Well, guilt of what, though, Greg? I mean, what are they guilty of? They're guilty of talking to each other. I mean, we're not, you know, we've got prosecutors here, 5 counties and 5 DAs coming out of the Milwaukee DA's office and Government Accountability Board. All these resources, and they're not looking at imminent heroin shipment. They're not looking at the kidnapping of 30 girls from a school. They're looking at, did Group A talk to Group B about an election? And that is called free speech. So no, they're not going to complain about a rule until they get prosecuted.
Whether or not the law is constitutional, I guess, can be argued, but it is clear that is right. But it is clear that that is the law currently. That if you cannot coordinate, and that Judge Randaz essentially said he thinks that law
unconstitutional law,
First Amendment rights. So to be clear on that,
yeah, for the first time. Like, have we ever heard somebody making that argument before, that collusion was a threat to the First Amendment? Absolutely not. It's only after they got caught.
Caught doing what?
Caught breaking the law. Collusion is illegal, Dave. It is absolutely
it's an unconstitutional
illegal.
Law. Though, I mean, you know, you're talking about, my golly, you know, they were trading alcohol. Well, that was eventually repealed because that was part of the Constitution. Now we're having Tammy Baldwin, one of 41 United States senators, basically wanting to geld the First Amendment. I presume you're behind that. You can say different. And I think James Madison and Thomas Jefferson got it right the first time. I do. And rather than Tammy Baldwin and Chuck Schumer.
I want you to explain first what you mean about Tammy Baldwin, and then second, Scott being behind it.
She is, I'm asking him, but Tammy Baldwin and one of 41 United States senators this week who have introduced Senate Joint Resolution number 19 to basically amend the United States Constitution, specifically the First Amendment, for the first time in its 223-year history, to basically allow the states to have greater regulation of the First Amendment. The proper regulation of political speech, Scott, I would say, is no regulation. Let people sift and winnow for themselves. There's a plaque up in Bascom Hall that says, we trust the people to decide what is fair and what isn't fair, what's true and what isn't true, and they can make their own decisions. I trust the people to use their innate intelligence.
Mm-hmm.
Do you?
What I believe is this: if they would like to communicate in that way with a campaign, then they should file this political action committee, they should pay taxes, they should disclose their donors, and they should follow all the rules that were in place before they violated them.
You know, the 7th District Court, Appellate Court, United States Federal Court, looked at the Government Accountability Board. Just in one chapter, they have 15 chapters, just in one chapter there are 39 subchapters, many of them many pages, and they said that, and Judge Diane Sykes, writing for the 3-0 majority, talked about a dizzying array of statutes and rules that are labyrinthine and difficult to decipher. That would take a $300 an hour speech attorney, and those exist, by the way. So that's what we're talking about. We're asking the government, may I please say something here about an election? That is so crazy. Government, Greg, has become the greatest enemy of the First Amendment of free speech in this country. And that's why you have the Bill of Rights to give the folks, people, their rights as opposed to government.
Governor Walker's throwing the Club for Growth under the bus and trying to negotiate a settlement in secret because he fears the release of these documents, because he knows how damaging they would be. People of Wisconsin are not going to tolerate this sort of reckless lawlessness, and so he has great vulnerability on that. It's as simple as that.